right, good afternoon. My name is Garett Berman. I'm the Executive Director of the Florida Prosecuting Attorneys Association. I've been in my position for about 5 years. Prior to that, I've been a prosecutor for 18 years. And as Adam Rossen said, I did start out with him probably back in 2007. We were trial partners together when I first started. So anything I guess you hear from me today that you don't like, you can probably blame on him. But we're going to go ahead and get started. And hopefully, if you guys all made it to the last session of the day, you are really interested in what the prosecution has to say about everything. So let's get started. All right, just a quick disclaimer. I do use a lot of things that were made by other people under the fair use guideline for instructional use, one of which happens to be one of the members of the Rossen law firm, Scott Simmons, who I guess the law firm graciously gave me his PowerPoint presentation to use and modify, and also an assistant state attorney by the name of Bob Pell out of the state attorney's office in the 14th Circuit, which is in Panama City. So to start today, the topics that we are going to go over are going to be including motions in limine and motions to suppress. We'll talk a little bit about jury selection, talk about cross-examination in both the state and the defense case, a little bit about JOA in DUI cases, and then talk about a few closing argument tips and tricks. Although I really don't like that word, tips and tricks, more like tips, not necessarily tricks. And then we'll kind of go over the sentencing chart that I believe Manny talked about earlier. So let's just jump right into things. And when we're talking about motions to suppress and the whole trial in general, really what we want to do is we're playing chess, and we want to be the best chess player that we can be. For example, we want to make sure that whatever move we make, we're seeing the entire board, we're scoping it out, and whatever move we decide to make, we make the absolute best move, whatever it's going to be. When we talk about an actual motion to suppress, what are we talking about? Well, the motion to suppress has to allege an unconstitutional search, seizure, confession, or admission. Everything that's listed under Florida Rules of Criminal Procedure 3.190 G and H. If it doesn't fall into one of those categories, then technically the exclusionary rule doesn't apply, right? And that comes from that case called Gonzalez, which should be on your screen now. The difference between a motion to suppress and a motion in limine is that motions to suppress may be directly appealed to the next highest court. When we're talking about motions to suppress, you want to make sure that your motion, if you are a defense attorney filing one, is sufficient that it complies with the rules. So for example, for motions to suppress under 3.190 G3, under the Rules of Criminal Procedure, the court shall make a determination if the motion is legally sufficient. If not, the rule says the motion shall be denied. So you got to make sure that when you're crafting your motions, you comply with what the rules say. What the rules say with regard to the contents of the motion under 3.190 G2 is that every motion to suppress shall clearly state the particular evidence sought to be suppressed, the reasons for suppression, and a general statement of facts on which the motion is based. Under H2, when talking about confessions or admissions, it says that the motion shall clearly identify with particularity any statement sought to be suppressed, the reasons for suppression, and a general statement on which the motion is based. So a lot of times as a prosecutor, what I'm doing is, especially if it's a motion to suppress a confession or an admission, what I'm doing is looking to see, has the defense listed out the specific statement? A lot of times what we will see as prosecutors is any and all statements. And the problem with that is going to be that it doesn't put the state on notice, first of all, of what admission or confession you're trying to suppress. And it doesn't put the court on notice, more importantly. The court needs to know that because they need to know what standard's going to apply. You know, we heard a lot about accident report privilege. We heard a lot about Miranda. A lot of different things come into play when we're talking about what statements, what admissions, what confessions are going to be suppressed or should be suppressed based on those situations, right? Obviously, Miranda, Law School 101, you need custody and interrogation. If you don't have one or the other, then that Miranda doesn't apply. So if the person's not in custody, should they have been read Miranda at a traffic stop? not including accident report privilege issues. So you want to be specific about what you're going to be suppressing and why. A lot of what the case law says about motions to suppress is that it is allowable for the court to deny a defendant's pretrial motion to suppress without a hearing if the motion is legally insufficient. And further, the state has to be on notice of all the issues that are going to be argued by the defense. There's a great case that came out of the 4th DCA probably about 5 or 7 years ago called State versus Christmas. It had to do with a defense attorney pleading in their motion at the very last paragraph, any and all arguments to be argued or a tennis. And the court found that that didn't put the state on notice as to what the additional arguments were going to be, and found that the court ruling on that issue was improper, and it actually set the case back down to the lower court to have the defense plead that motion properly. Motion in limine basics, just the opposite of a motion to suppress. It's basically not dealing with a constitutional issue. It's asking for an evidentiary ruling before trial. These are not codified in the Florida Rules of Criminal Procedure, and we don't get a direct appeal from them, but we do have to go through cert if we do want to try to appeal. But keep in mind, motions in limine are not motions to suppress. A lot of times what I've seen as a prosecutor is a defense attorney will file a motion in limine, or what should be a motion in limine, and title it as a motion to suppress. And a lot of the difference there, really, when we're arguing motions in limine, motions to suppress, is usually in a motion to suppress, the state is going to have the burden for the most part. With a motion in limine, it falls on the moving party to plead what it is they're trying to keep out, and they actually have to plead that by specifics and not just say, well, state can't get X, Y, Z in. For example, a lot of times most people will file a motion in limine. Most defense attorneys may file a motion in limine trying to keep out the breath test. The problem with that is in 2013, the United States Supreme Court, 2016 or 17, came out with a case called Birchfield versus North Dakota. And in that case, the Supreme Court talked a lot about whether or not the field sobriety test, the breath test, and the blood test were invasive tests that needed to actually have the consent of the defendant. And the court, through its analysis, goes through SFSTs and said, that's not even applicable here. In talking about breath tests, they did find that the breath test was a reasonable search. Now, the Fourth Amendment prohibits unreasonable searches and seizures. So as a prosecutor, my argument is, well, if the United States Supreme Court has said that a breath test is a reasonable search and it doesn't run afoul of Fourth Amendment prescriptions, well, then a motion to suppress is not the right vehicle to keep out a breath test. If there was something that was wrong with the breath test or with the administration of the breath test, then that is right for a motion in limine. And the defense would then bear the burden to show why a rule wasn't followed, or somehow the breath test results are not accurate or reliable. So in talking about motions, all right, some do's that pretty much both sides should follow. Be as specific as possible what you want to suppress or in limine out, whatever it is, both sides. If you took a deposition, if you're the defense, you took a deposition, or if you're the state and you take the deposition of a defense witness or even a defense expert, know specifically what you want to keep out and quote directly from that deposition. If you're going to cite to any applicable case law, any applicable case law or any rules of evidence, make sure you do so in the motion itself as well. Some more motion do nots. Do not file a boilerplate motion to suppress or a motion in limine. I know as practitioners, we all have them. I still have the same motion in limine that Adam and I first used back in 2007, and I'm pretty sure that that is still being tossed around the state attorney's office to this day. It has good case law in it. The problem with using boilerplate motions a lot of times is we get caught up in using the motion and we forget to sometimes go back and check to make sure the case law that we cited years ago is still good law. Don't simply cite to a case or state any rules of evidence without explaining how they're relevant to the actual facts of your case. And no matter what side you're on, don't file a motion at 2 a.m. the night before trial or amend a motion just before an already set hearing. That's a good way to really do damage to your reputation, no matter which side you're on. So talking a little bit about DUI motion specific motion and limine topics. So hearsay and confrontation clause issues. Obviously, statements made through dispatch, any unlisted witnesses shouldn't be elicited by either side. Same goes for any uncharged crimes. That applies to both sides as well. Obviously, the defense should not be able to talk about the defendant never having been arrested or convicted of a crime or a felony. But the state may also want to keep out the fact that the defendant doesn't have a right to consult with an attorney before deciding whether or not to submit to the field sobriety test or chemical testing. I'm talking a little bit about field sobriety exercises, right? We cannot say that they are tests. Obviously, we can't use the words pass or fail when referring to the performances on the exercises. Although I will point out, I do think it's funny that several of the previous speakers have referred to the SFSTs as tests. There was talk about pass and fail. So just definitely be careful when you're in court and you're starting to talk about the SFSTs. And I do say standardized field sobriety tasks or field sobriety tasks, field sobriety exercises. At least that's how I do it. That's how I train people to do it, field sobriety exercises or field sobriety tasks. Now, the seminal case on field sobriety exercises is Meter, right? And Meter basically says that the psychophysical tests or the psychophysical portion of the field sobriety test battery, that is lay observation. But when we get to HGN, the court kind of said, not so quick. HGN is actually scientific. And therefore, the court noted there was a distinction between talking about the symptoms of nystagmus, meaning, can I talk about someone's eye jerking left to right? Can I see it? Sure, I could see it. Can I talk about it? Sure. But where they drew the line was, can that person actually then relate those symptoms of nystagmus and correlate it with alcohol impairment? And the court said, no, they can't unless they're an expert. Now, a lot of times, some people kind of take Meter to say, hey, the officer can't testify about HGN unless they are DRE certified. And I will say that that is absolutely not true. That is not the case. Like any evidence that is scientific that is being testified to, the person has to be an expert. There is nothing in Meter that actually says that the individual has to be a DRE, because you could obviously get a doctor, a neuroscientist, a nurse to be qualified as an expert to talk about HGN, and they have been. If you look at the case law on HGN, Williams talks about a properly qualified DRE can testify to HGN results. And Bowen even talked about a trooper was qualified and trained to give testimony on HGN, where they took a 40-hour course which discussed HGN and then had administered the test about 1,000 times. Now, the court doesn't say that 1,000 times is a bright line rule. It has to be 1,000 times. But the court found that the trooper was qualified to talk about HGN. Stepping back for a moment, Adam was kind of talking me up in the beginning there a little bit. I am a big proponent of the fact that as prosecutors, we should not be questioning our officers about things that we ourselves have no experience in. For that reason, I have completed training as a DUI SFST instructor. I have taken the A-Ride course. I have completed training as a drug recognition expert. And I have, I hold certifications as a breath test operator, as an agency inspector, as well as a breath test instructor, so I can also teach. And I have pretty much done a lot of the things that a lot of the officers who I have come to know over the years and a lot of the prosecutors that I've trained, I have taken those courses so that I am better able to explain a lot of this stuff. That being said, are you always going to get someone like me in the courtroom against you? Chances are probably not. You're going to get that person who's about 6 months out of law school, probably scared to death trying to remember everything that their supervisors just told them. But I bring this up because HGN is one of those things that, I feel personally I could testify to if I had to. And I could correlate how that applies to the impairment of an individual if I'm seeing that HGN. So some other topics regarding DUI specific motions, right? An officer can't testify to their opinion that the defendant is guilty. However, right, officers can testify to observations of impairment, and they can give an opinion whether or not someone is impaired. Here are two great cases that talk about, anyone can give testimony that someone is impaired either by drugs or alcohol, providing they have the opportunity to observe them. Cannon v. State, I like to joke that's not a typo. That is actually from 1926, and it is still good law. And City of Orlando v. Newell, both of those cases basically say that as long as the individual had an opportunity to see, observe, hear an individual walk, talk, and just go about whatever they were doing, those individuals are allowed to give an opinion as to whether or not the person was impaired somehow by drugs or alcohol. One of the other specific motion in limine topics, and Adam talked about this at length earlier, is failure to maintain single lane, right? Under Florida Statute 316089, it talks about, having to stay in your lane, as much as is reasonable, and not deviate from the lane unless the driver has ascertained that it is safe to do so. There was a really good case, and I know Adam said this, a lot of the people who practice a lot of the DUI stuff, we are DUI nerds. We do stay abreast of the case law, and there was a really good case law that just came out probably about 18 days ago from the 5th DCA. Is a case called State v. Howard. Citation on Westlaw is 2025 WL 1349035. Defendant was driving 69 in a 45, but he happened to be straddling the two lanes, and the officer who didn't put on his radar, did not properly pace the vehicle, was trailing behind, and the defendant was straddling the lane fully over the lane divider for about 15 seconds. The officer eventually makes a stop, and the trial court found that the officer's stop of the defendant based on that reason was invalid because the court found that no other traffic was affected by the defendant's vehicle. It goes up to the DCA, and the DCA actually reversed, explaining that the trial court had only based its decision on finding that the defendant's driving pattern didn't affect any other traffic. However, the court said that the trial court only considered the latter part of the statute, i.e. whether the movement could be made safely, and did not consider whether the defendant was driving, as the statute required, as nearly as practicable entirely within a single lane. So I think we're starting to see a shift from just the whether or not traffic was affected part of the yanes and the crooks and the herd progeny. And what we're really seeing is now this has become a two-part question. It doesn't just always hinge on whether or not any other traffic was affected, but it's also going to hinge on whether or not the defendant was driving nearly as practicable in that lane. Excuse me. So other things to consider, right, with your motion in limine. If something is limited out, if something is suppressed, as a defense attorney, obviously make sure that the state makes those redactions to those video, to the body cam, to the dash cam, to the, whatever other cam you got. And make sure they do it immediately. As a defense attorney, I would not wait until the last minute to make that request to the prosecutor, because that's going to look bad on you to the court. But the converse is also true. If you tell the prosecutor specifically what you want redacted or what should be redacted, and they don't get it back to you, then that's on them. As prosecutors, we need to make sure that we make those redactions as soon as possible. And usually what I'm doing is I'm making my redactions and I'm telling my younger prosecutors, as soon as it's done, get it to the defense and make sure they sign off on it. Make sure they agree, make sure we're not missing anything, because if so, you got to do some more redactions and get it done properly. Okay. Case law. Both sides, I think, should bring 3 copies with them to court. One for yourself, one for the judge, one for the opposing party. If you're going to highlight anything for the court, make sure you highlight it for the opposing party, whether state or defense. I think that's only proper. Usually for that reason, I don't highlight anything but my own copy, and you can do that too. If there are going to be any redactions or any of the case law, like I said before, make sure you agree or get the other side to agree to it beforehand. It saves a lot of issues later on down the road. Both sides, get the judge to rule on every single issue that there is, right? If I'm the state, I want the judge to rule on everything, grant it, deny it, whatever, but I want the court to make that ruling so that if I need to appeal, I can. Same thing with the defense, right? You want the judge to make a ruling on the issues that you bring up so that you can appeal if you need to. For the defense or the state, even if your motion in limine is denied, you're still going to object during trial to what you wanted to keep out. Otherwise, you're going to be waiving that issue for appeal later on down the road. Okay. All right. So for just let me kind of take a step back for just 1 second before I move on to Voir Dire. I'm not sure if you guys are seeing this or not, because I'm not, and I apologize. So when talking about, I know Adam touched on this a little bit in his presentation, but he was talking about accident report privilege. And I wanted to point out that there have been 2 recent cases that have kind of shifted how accident report privilege is being applied nowadays. And both of these came out of the 4th DCA. There are 2 cases by the name of State versus Bender, which is 357 Southern 3rd, 697, and State versus Blocker, which is 360 Southern 3rd, 742. Now, in both cases, the 4th DCA reversed the trial court orders that essentially suppressed statements that were made at the scene of a traffic crash on the trial court's misconceptions of how the accident report privilege is to be applied. So in Bender, the 4th DCA disagreed with the trial court's conclusion that the defendant's detention was tantamount to a de facto arrest and that the officer had to provide Miranda rights as soon as the crash investigation turned into a criminal investigation for DUI. And the 4th DCA kind of quoted from a 5th DCA case called Vedner v. State, which has been overlooked for decades now. And that citation is 849 Southern 2nd, 1207. And what the 4th DCA said was the officer had announced that the criminal DUI investigation was underway when Bender made the statements at issue. So this was no longer a crash investigation required by 316.066 and was an investigation to which the usual rules and precepts associated with Miranda seem to apply. The DCA then found that Bender wasn't subject to the restraints of a formal arrest, right, no custody, when she made the statements that the county court had suppressed. So right there, we're seeing a shift away from that whole change of hats that Adam was talking about earlier, in that the fourth DCA is basically said, well, once the officer has told the individual that this is now a criminal investigation, well, the precepts with the accident report privilege no longer apply. Now the precepts and rules with regards to a criminal investigation apply, and Miranda doesn't apply if there's no custody and no interrogation. So then the court, about 3 months later, decides Blocker. And in Blocker, the court basically reiterates its ruling from Bender that the Miranda warnings were not essential for an officer to signal a shift from an accident investigation to a criminal investigation. Instead, the court found that the Miranda warnings were required only if the defendant had been subjected to custodial interrogation. Citing to a Florida Supreme Court case called Nordstrom from 1993, the court said further, if a law enforcement officer gives any indication to a defendant that they must respond to questions concerning the investigation of an accident, then there has to be an express statement by the law enforcement official that this is now a criminal investigation, immediately followed by Miranda before any statement by the defendant can be admitted. So when you look at Nordstrom, really, we all want to look at that last part, especially if you're a defense attorney. You're looking at hey, there must be an express statement of law indicating a change of hats. It's now a criminal investigation. Got to read Miranda. But what it seems like the fourth DCA is really doing now is taking a much more stringent look at that part of the Supreme Court's holding and saying, well, was the individual told that they had to respond to questions concerning the investigation of the accident? And we all know they have to, by statute, everyone is required to report what happened in a crash, but there's no way to force an individual to do that. And that being the case, right, the officer, if the person decides, hey, I don't want to talk to you about the crash, and the officer says, no, according to the statute, you must, well, now they've given an indication to that individual that they must answer questions. And at that point, changing of hats, reading of Miranda would be required to get in any subsequent statements at that point. All right, so let's talk a little bit about jury selection. And I hope a lot of these things are coming up. I tried to include a little snippet from a movie, The Judge, with Robert Downey Jr. and Robert Duvall. If you haven't seen it, please, give it a shot when Robert Downey Jr. is selecting the jury. It's a really good, funny look at the type of people that a defense attorney is looking for the jury. Really interesting. But anyway, so let's look at the goals of Voir Dire, right? What are the goals? Well, to be totally honest, right, we're not selecting the jury. We want to exclude any of the jurors who are not good for our case, whether we're state or defense, right? The legal response to what the goal of Voir Dire is to obtain an fair and impartial jury, okay? I'm not looking for that as a prosecutor, and I'm sure you defense attorneys are not looking for that as your jurors. You want people who, if you're a defense attorney, who are going to find your defendant, your client, not guilty, right? People who want to have reasons to find them not guilty. Whereas for the state, I'm really looking at people who, want to convict, people who don't want to give them an excuse to get out of whatever crime they're charged with, right? So the legal reason is to obtain a fair and impartial jury, but what are we actually doing? Well, we're starting conversations with them. We are trying to gain trust. As a prosecutor, I often tell my younger assistant state attorneys that from the moment you set foot in that courtroom and the jury is there, they are looking you up and down from the moment you enter, from the moment they enter. They're looking at you, how you interact with everybody, whether it's court personnel, whether it's with the defendant, whether it's with the defense attorney, whether it's with the clerk, the in-court deputy, right? They want to figure you out, all right? They want to know, can they trust you, okay? You also want to address with them in your conversations, what are the weaknesses of your cases? What are the strengths of your case? Can you further your case theory, whatever that might be, right? Maybe you want to try to preview your case for the jury, even though a lot of times we're not allowed to, right? We can't pre-try the case, but there are some legal issues that both sides have to talk about. You want to encourage them to follow the law. I definitely do. There are some great things from the jury instructions that I will always point out to the jury, right? For over 200 years, we've all lived and died by the same rules, right? No one has the right to not follow the rules we all share, okay? I love to end with that. I usually won't bring it up in Voir Dire, but I like to do that. But I need to find out, can they follow the law? Does anybody have a problem in following the law? Does anybody not believe in DUIs, right? Usually try to find who are the one or two people who's going to be leading the group if they get selected. Because when they go back into the jury room for either side, those are going to be the people who are going to kind of control things. They're the ones who are going to be your jury foreman, okay? And then the rest is you want to identify and eliminate anyone who you don't want, and get those kicked off either by for cause or using a peremptory, right? So what do you want to do in finding out someone's biases? Well, you have to be the person who leads the conversation. You're going to have to ask them and talk to them about their biases. What do they have, right? But you shouldn't be doing most of the talking. That should come from your jurors. You have to hit up every single juror at least once for important questions, because if you try to challenge out whether it's peremptory or cause later on and no one's talked to a particular juror, you're going to have a hard time doing that and getting that juror kicked, because you're not going to have a reason to. Notes, I believe, are very imperative to what we do, whether or not you have a trial partner or not. Some people like to say, well, I can remember everybody's name and their seat position and everything else. And I'm sorry to say, in 18 years, I've never been able to really do that. So if I don't have someone with me, usually you'll have a chart. Figure out your own shorthand, what you're going to use as abbreviations, excuse me, symbols as to what you're going to use to note things down, because you're going to have to move very fast. If you've never picked a jury, right, this is going to seem very, very difficult for you until you've done it a few more times, so you can kind of get your shorthand down. You kind of know the questions that maybe your judge is going to ask from time to time. Excuse me. And, another thing is, most judges have a lot of the same questions that they'll ask over and over again. They'll have a set of standard questions that they will ask. So you want to be sure to have those questions at the ready and kind of make your shorthands on your charts as quickly as possible. Time limitations on voir dire, right? The courts have said that the trial court has the inherent authority to control the scope of voir dire, right? But each case is going to have its own possible time limits imposed. There was a recent case that came out, I want to say within the last month, by the name of McMath, which basically held that the trial court's limitation of voir dire to 75 minutes total for both sides was proper and did not run afoul of what the case law said the court could do in its time limitations, excuse me. And I already talked to you guys a little bit about the questionnaires, but figure out what questions the judge is going to ask and then try to follow up with those answers or questions that the judge did not ask in order for you to properly vet your jurors. So some popular voir dire topics do include, right, is drinking and driving legal, right? Yes, drinking and driving is legal. If it wasn't, we wouldn't have parking spots at bars. But obviously that's not what we're here for, because what we're here for is whether or not the defendant drank and drove while they were impaired. Okay, it's that impairment part that really is what the state has to prove. Is it illegal to drink a glass of wine at dinner and then drive home? Well, yes. As long as it's maybe one glass of wine, maybe an hour has passed, maybe the individual has eaten a lot. Okay, on its own, is it just in a vacuum? Okay, sure. But how do you determine if someone's impaired? And you may look to your jurors to answer that questions a lot of times. Sometimes it'll open up a whole can of worms that you weren't expecting. You may get the real expected answers, right? Odor of alcohol on their breath, bloodshot, watery eyes, they can't stand, they're swaying while they're standing. You want to be careful, but at the same time, if you're not getting the answers that you want, particularly if you're the state, if you're a prosecutor and you ask, well, how do you determine impairment? And the individual doesn't know, well, you may want to suggest some things. Well, what about this? What about this? Same thing for the defense. If you're not getting those answers, you may need to suggest some things. You also want to talk to anyone who doesn't drink, anyone who may be a social drinker, anyone who, college students, are you hitting the bars every week? Bartenders, for me personally, I may want a bartender. I may want someone who's been convicted of DUI, especially if that individual has pled their case, because more likely than not, they may be looking at the defendant saying, well, hey, I took my lumps. Why aren't you taking yours? Now, sometimes your case is either going to be a breath test, and sometimes it's going to be a refusal case, or it could be what the prosecutors call a double refusal, meaning they refused field sobriety exercises and they refused the chemical test, whether it's a breath, urine, or blood test. Whatever that is, you have to handle that in your jury selection. Okay, so if it's a refusal, all right, if you're the defense, maybe you want the jurors to tell you why the defendant refused, right? What are some reasons why an innocent or guilty person would refuse to admit the breath test? Guilty if you're the state, right? What are some reasons for the refusal, right? For the defense, it's going to be, there we go. Don't trust the instrument. They don't trust the instrument. Or I'm sorry, if you're the defense, you're saying machine. Don't trust the machine, all right? Or they were already under arrest. It's not like they were going to be unarrested at that time. Or maybe they were annoyed at the officer, okay? For the state, it's consciousness of guilt, right? They knew what the results would be, or they were willing to lose their license for a year, right? As one of the speakers earlier said, it's actually a harsher penalty for someone who refuses the breath test. Why? Because the other person follows the law, that implied law about submitting to the test. And I know there was talk, I guess, about the refusals and the criminal charge. I think maybe Manny touched upon that. If a lot of you don't pay attention to what bills are being passed at the legislature this year, there was House Bill 687, which makes some enhancements for DUI manslaughter and vehicular homicide, BUI manslaughter and vessel homicide. But one of the things they added back at the last minute was that now, once the governor signs it into law, which we're all assuming he will, as it's been passed on to him, a first refusal now will carry with it an additional charge of a second-degree misdemeanor. So a first refusal, second-degree misdemeanor charge will apply should the governor sign it. And if he does sign it, that looks to go into effect October 1st of this year. So moving on, if it's a breath case, right? You heard the last speaker talk about how the intoxilizer works or doesn't work, or as he said, the breathalyzer, it is the intoxilizer. Do they trust all forms of science, right? Sometimes there's a doctor analogy. Maybe you all, I've heard individuals use that they want to get a second opinion. Okay. Um, from the state's point of view, I don't know how a car works, right? All I know is I put my key in, it works. I don't know. I know it's a combustion engine. That's about it. I can't tell you how the science works on it. Okay. But I also say I can use my car to get from home to work Monday through Thursday. And just because it didn't work on Friday doesn't mean it didn't work Monday through Thursday. The other thing too is I know there was talk about the intoxilizer being so old, and yeah, that is true. It is a very old instrument, but I don't really see a reason not to trust it. I find a lot of times, we use things today that are still very old, and we still use them. Think of how many times someone takes your temperature with a mercury thermometer, or how many times they did before we stopped using it. Um, those things have been in use for over 200, 300 years now. But why wouldn't they trust it, right? You want to talk to your jurors about that. What other scientific devices do they trust that they don't know exactly how it works, right? And then I already gave you my thermometer analogy. But also, don't forget your basic topics when you're doing a voir dire for a DUI case, right? Don't forget, if you're the defense, you may want to talk about the presumption of innocence, right? You may want to talk about the burden of proof. As the state, I'm going to talk about the burden of proof, right? Are you going to talk about reasonable doubt? What is reasonable versus a possible doubt? Okay, where does this reasonable doubt come from, right? Use your jury instructions, conflict in the evidence, lack of evidence. If you need to, you can always ask the judge to read the instruction if that's the case, or read from it yourself directly. Perhaps you have a case, if you're a defense attorney, where your client may want to testify. Maybe you want to talk to the jury about that in your jury selection. Maybe you don't. Maybe both sides want to talk about the credibility of witnesses if they have witnesses. And, for the state, maybe you want to talk about the credibility of one witness with a lot of documents of evidence versus 10 witnesses with only one piece of evidence, right? What is the jury's, tipping point for how much is enough? Also may want to talk about the CSI effect. Right? Television kind of strains how we look at a lot of things with technology, especially technology that doesn't always exist. Does the jury understand that this case is not going to be resolved within 44 minutes, barring commercials? Okay. And then maybe talk about, if you're the state, sympathy and bias. Okay. You may want to talk about, are they going to have sympathy for the defense? Because the instructions are going to tell them not to. We heard a lot of talk about humanizing the defendant and humanizing their client by the defense attorney. For the state, right, they don't want the sympathy to ruin the facts of their case. And maybe sum up other questions at the end. Anybody who just can't sit in judgment of anybody else for whatever religious, ethical, or moral reasons. They're not asking you to judge the evidence, but I'm sorry, not asking you to judge the person, but just the evidence. Excuse me. What about holding all people accountable for their actions? Those are some questions that, as a prosecutor, you may want to delve into. Now, what are some typical DUI areas? Experience with law enforcement officers. Has anybody had any experience with them? You're going to want to know, was their experience good? Was it bad? Do you think that they were treated fairly? Impairment versus drunk. Some prosecutors, and I've used this in the past, right? If I wear glasses, if I take off my glasses, do my eyes just automatically stop working? Or is my vision impaired, right? There is a difference between the two. What about effects of alcohol versus drugs? What about tolerance? A lot of people may look good because they look good on their field sobriety exercises, but they're still blowing a 0.15 or a 1.8 or a 2.4, whatever it is, right? Obviously, the defense argument is going to be, well, that instrument, that machine isn't working properly, because that's not what you're seeing on video. And I'll be the first to admit that most jurors, they will go with what they see rather than that number. What about prescription drugs versus other drugs, like say controlled substances, right? Obviously, prescriptions can be for controlled substances. If they weren't, there wouldn't be a prescription for it. So you want to make sure that you talk to your jurors about that, whether or not that matters for the state, whether or not that prescription is going to be a license to drive in their minds for some of those jurors. So next, I put some case law about Voir Dire, and I know I'm getting a little tight on time, so I want to make sure, that everyone's kind of on the same page when it comes to Voir Dire. Obviously, both sides have a right to Voir Dire, the jurors, but there's that good case, Walker v. State, that talks about hypotheticals and how we can use both sides use hypotheticals. But what we can't do is question jurors about what type of verdict they would give given a specific set of facts. Okay, we're not allowed to do that. We shouldn't. And I will be the first to admit, I have freely done it. I have seen defense attorneys freely do it. And we really shouldn't be, because that's not what they're there for. We should be using the hypotheticals to kind of understand how the jurors would feel about certain laws and if they could apply certain laws and certain theories of our cases. Let's see what else. So I'm going to kind of gloss over those a little bit, and you can kind of take a look at that. One of the interesting cases I did come across was a case called State versus Felton, which talked about that there is no actual right to talk about comparing and contrasting the burdens of proof. I have seen many a defense attorney talk and compare and contrast the burdens of proof between a criminal case and a civil case, and technically there is no right to do that. The fact that there was a restriction on it, and the court did not allow the defense to do it, the DCA basically found that there was no issue, there was no merit to that argument. The other thing I've seen a lot is this Juetti case, or Juetti case, however you want to pronounce it. I know a lot of times the defense will sometimes say that this stands for the proposition that rehabilitation does not work. And I really think that that's fact specific to the case and what was said by the juror, and how it was said. In this particular case, it was a juror who was basically adamant that they couldn't be fair and impartial when it came to officers, that he would definitely give them more credit than he would any other witness. He would give them more weight because of the uniform. And he had stated that 3 different times he would believe an officer over a lay witness. And sorry to say, I agree with Juetti in that case. There was no rehabilitating that person, even when he said afterwards, yes, he could be fair and impartial and he could follow the law. There's just no way that was happening. Okay. This was another clip. Hopefully you've all seen it, from My Cousin Vinny. Basically talk about openings, right? Hopefully everybody knows what Vinny says. Everything that guy said was BS. Thank you. And obviously you're not going to be doing that during your opening. But what do we want to do? What do we want to get out of opening, right? Opening's the first time you're going to actually be talking to the jury about your case. You want to persuade the jury, right? Openings persuade, closings are going to confirm, right? So you're going to want to tell them, hey, this is what you're going to be seeing. Then with the trial, you're going to show them. And then in closings, you're going to say, hey, look, this is exactly what I just showed you, right? A lot of times, there's a scientific reasoning behind repetition. You want to be able to tell somebody something at least 3 times before they actually get it. So tell the jury what they're going to see, what to look for, right? And if you're the defense, what they're not going to see from the state's case, because there may be a lot, right? Obviously, you don't want to wing it. Studies show that 75 to 80% of people make up their minds after the opening and they don't change it afterwards, no matter what was said, because people have a natural inclination to pick a side and stay with it. For the state, some suggestions. You have the advantage of going first, so strike while the iron's hot, right? Explain the case in the best light that you can, but don't hide bad evidence, okay? Maybe hide it in the middle of your opening, in the middle of your case, but it's not something that you should shy away from, especially when you know the defense is going to point it out. Introduce the players, right? Credit your witnesses, build rapport, and enhance your own credibility with the jury, because you're going to tell them, hey, you're going to see this, and then they're going to hear it and see it from your witnesses. For the defense, right, and I think we've heard this many times before, is humanize your client, right? You're not going to be calling client defendant. It's always, my name is so-and-so. I have the honor, I have the privilege of representing Mr. or Mrs. So-and-so. Emphasize the burden in your case, that the state has it. It's on the state to prove it, right? And if they don't, that should be a not guilty, right? Tell them why they're going to be finding your client not guilty, okay? Tell them what questions the state will not be able to answer, okay? And some themes, some suggestions for both sides is pick a theme. Maybe you want to stick with, state always loves to use the choices theme, okay? But what about for the defense? Mr. or Mrs. So-and-so is not guilty, right? Start off with that and go through the entire way, but to the end of trial. But I would say this, if you are going to promise something, especially as the defense in trial, be sure that you show it. I have taken part in many cases where I have used what the defense has promised the jury they would see, or what they were going to show the jury in closing, to show that they never saw that. And if all else, be yourself, right? That's the one thing that, jurors can kind of see through, is when we as attorneys are being phony. Don't oversell, right? Like I said, it is going to come back to bite you one way or the other. And don't take away from your own openings or even your own closings. Don't say what I say is not evidence, for both the state and the defense. Because be sure, if I'm getting up at closing, or if I'm getting up at any other part of the trial, I'm going to say that what the defense says is not evidence, right? Don't read it, kind of prepare it, make sure that you take your time with it and try to get it down to bullet points, because obviously if you're taking this case to trial for both sides, or should know your case, and what the high points are, so you don't have to have everything written out. You can kind of go with bullet points. So some other tips for opening, and I would say this goes for both sides. Be brief, especially for the defense, because if the jury is just sat there going through jury selection and then they heard the state's opening, they are probably listening to you give your opening with the sole intent of, how long is this person going to keep me here? I need to get out of here. When's lunch? So try to be brief, both sides, but especially for the defense, I have seen a lot of defense attorneys take their openings way too long, and sometimes you can see it in the jurors' faces. That's not to say that you don't hit everything that you need to hit, but try to say it in the briefest way possible for both sides. So cross-examination, again, this is going to depend on your witness and what you want to get out of your witnesses. And I got about 10 minutes left, maybe 5. What is the goal? Well, the goal is to weaken, test, or demonstrate the impossibility of that testimony, or to impeach the credibility. And a lot of times that's what both sides are going to want to do. Now, the defense is going to have more opportunities to do this, because more so in a regular DUI case, the state is not going to be on cross-examination. I know there was a question earlier about whether or not you should hire, as a defense attorney, experts. I say take it as a grain of salt, because a lot of the experts that you may be hiring are going to come with their own baggage that the state absolutely knows about, particularly me. I keep files and folders on probably most, if not all, of the DUI experts that come through or have testified in Florida. But what do you want to do with your cross-examination, right? You want to lead them. Obviously, if you're a defense attorney, you should always be leading any witness unless they're the ones that you call, right? One fact per question, right? Take your time, listen to the answer. Make sure you listen to the answer and not just jump to the next question on your list. Don't argue with the witnesses. Don't ask them the answer to a question that you don't know the answer to, right? That one question too many. If you don't know the answer to the question, you shouldn't be asking the witness, and that goes for both sides. And be prepared to impeach, but be prepared to impeach correctly. Having said that, review everything, right? You may want to write out your cross-examination of your officer, right, to get your reasonable doubt. What are you going to focus on with the officer, right? The lack of evidence, lack of impairment, the stop, the pre-investigation, what they did do, what they didn't do correctly, the FSEs, which I'm not going to go into that because the last speaker did a great job in trying to tear them down. And what are some other things that you want to talk about during the cross-examination, right? Lack of impairment, what the officer did wrong, right? What that all means in the whole scheme of the totality of the circumstances for that case. And let me just kind of skip ahead just a little bit. When we're talking about what are you going to do for cross-examination for, say, for example, of course, I can't see my slides, so I'm sorry, guys, with field sobriety exercises. There was a lot of talk about what certain things mean, how certain things can mean other things, and, isn't it true? Red eyes could mean that the person was around somebody who was smoking a lot. Could it mean that they were tired? It absolutely could. I think, though, you have to do that if you are a defense attorney, because those are the standard ways that you are going to get somebody to find reasonable doubt. Maybe that one juror is going to say, oh, absolutely, they were, that's because they were smoking, or that's because cigarettes, or that's because they were up all night working a double. Okay. Some of the other things too, and I've heard this, and this will be me being a little bit nitpicky, but did the officer give the right instructions according to NHTSA? I don't really care. As a prosecutor, I'm only concerned with what did the officer tell the individual, and did that person do what the officer instructed? If not, I don't care about reliability. I don't care about NHTSA. I don't care about anything. Just what did the officer tell them? Were they able to do it? The goal of these SFSTs is so high. It's not, though. Having been an instructor, I can tell you that a lot of these things are very easy for someone to do. And I think as a defense attorney, you may want to be careful about saying that, well, this person needed to practice doing this, because if they needed to practice doing this, and there's a really good driving pattern for the state in your case, what does that say about how they were driving? Did they need to practice driving a little bit more before they got it right? Or should they know? Why is it so difficult for an individual to listen to instructions and then follow what they are not only told, but shown? Attacking the breath test, right? What are some reasons why the breath test, why or how you would attack the breath test at trial, right? Obviously, the operator isn't going to know how to, let me see if I can get on the right slide here, guys. Okay. The prosecutor is not necessarily going to know how the instrument, the breath test operator is not going to know how the instrument works, all right? They just turn it on and they tell your client to blow. That is absolutely true. I often joke that it honestly takes a PhD to get a permit to conduct evidential breath tests, and that is because the PhD stands for push here dummy. The intoxilizer is completely automated, meaning that once they push that button, they enter in the information that they need to, the instrument runs itself. But that having been said, the breath test operator is not your expert. They're not going to be able to answer a lot of the questions that the previous speaker talked about because they don't know it. They are not taught that. They're not going to know, they'll know about a 20-minute observation. They're not going to know about partition ratios. And I will say there are several ways, to attack the breath test. As a defense attorney, I would expect you to use them all. Right? The breath sample usually isn't taken until an hour after driving, usually, but maybe not, right? There was talk about intoxilizers being in the back of officers' patrol vehicles. And I heard one of the speakers say that was an issue in and of itself. Again, I would say it's not. The intoxilizer is by its nature a mobile instrument, but that's neither here nor there. The state needs to prove the BAC level at the time of driving, not an hour later. And that is true, but there is a case called Haas v. State, which basically says that the courts have taken the breath test result when it's been taken to mean what it was at the time of driving. That doesn't really obviate the need for the state to prove that the breath test result was what it was at the time of driving or higher. But that's something that you'll have to talk to an expert about, or even the agency inspector if they know. The breath test operator can't tell you if your client was eliminating or absorbing alcohol. Definitely not the breath test operator will be able to tell you that. Possibly an agency inspector might. But then again, there are some breath test operators who are not just civilian breath test operators. They may be officers, they may be BTOs, they may be AIs, they may also be breath test instructors, so they might be able to do that. You just have to be careful with which witness you're asking that question to. The breath test operator, I talked about that. The breath test operator doesn't know how the instrument works. And yes, blood is more accurate. I don't know if you're a defense attorney, if you want to start talking about blood in a case where there's not blood, because then we're opening up a whole other can of worms, because we can't force anybody to submit to blood. But look, if you're the defense, you're definitely going to be attacking the instrument and you're going to be attacking the science. Like the previous speaker talked about, the partition ratio, 2100 to 1. I can't tell you how that works. In all my classes, I understand how Henry's law and all that, and understand the theories behind it. But the case law basically says that at 2100 to, the studies actually say at 2100 to 1, we are underestimating what the BAC would be based on the blood. And the lower we go, the further we are underestimating it. So obviously there's a complete desire on the part of the defense to want to go down to 900 to 1, because that obviously is better for the defense. But there is actually a case called State v. Brigham, which is at 694 Southern 2nd 793 out of the 2nd DCA in 97, which does talk about how there is no partition ratio issue anymore. It does a really good job of doing the analysis of the 2100 to 1 partition ratio and Henry's law from the court's perspective. So I would definitely check that out before you start doing that. And also, this also comes down to standard motion in limines, especially on the part of the state. If you're not filing a motion in limine to keep out any arguments of partition ratio, you are doing yourself and your case a disservice. Let's see. All right, so JOA in DUI cases, hopefully if you've ever been to trial, you know the two JOA burdens. The first one is that the state basically failed to prove a prima facie case of DUI and all those elements. And the second JOA, after the defense has rested their case, is that no reasonable jury could find beyond a reasonable doubt that the defendant committed the crime of DUI. Basically, if you're the defense, you're attacking every element. Did we prove everything? Driving or actual physical control, impairment by alcohol, chemical, controlled substances, to the extent the normal faculties were impaired. Did we properly get venue in? And did we establish the identity of the defendant? Okay. Okay, let me move on here a little bit. All right. This was a slide that was kind of left over from Mr. Simmons, and I don't really think that I'm in the best position to talk about whether or not the client should testify, because obviously, I've listed some pros and some cons here. The pro is, well, at least for the defense, it could lead to reasonable doubt, could let the jury understand and know your client a little bit better, and it can explain away the signs of impairment that the state has proven. But some of the cons are they could come off as looking really bad. They could incriminate themselves, especially if you have a really good prosecutor on the case, and perhaps they don't really have nothing to add to the whole situation, and is only going to make things worse. So moving on really to closing argument, this is the time for you to shine, whether you're the state, whether you're defense. It's your time to bring it all together, right? No matter how bad your case may be, I truly believe that confidence is the key. If you believe in your case, you believe what you're saying to the jury, even though you have a bad case, that could be enough to persuade them. You want to make all the connections between all your reasonable doubt and why the state hasn't proven your case if you're the defense. But if you're the state, how everything lines up together, right? Adam talked about earlier about chipping away at an ice sculpture. And the more you chip away, the clearer that picture comes into focus, right? And that's a great analogy. I've never heard that before, so kudos to him. But, just like, Adam's chipping away, right? The state is putting all the puzzle pieces together, right? And the more pieces that they get to fit, the clearer everything becomes. It's almost like the converse of the ICE statute, where you're taking all the pieces from the statute and you're putting it back together after someone smashed it. Do you necessarily need every little single sliver to go back into place? Or is it enough that you get the major pieces together so that you can see what that sculpture was? See real quick, talking about, let me move back. Talking about closing argument formulas, right? Some of you may use a theme. If you do, try to keep it and incorporate it throughout your closing, right? This is your time to review your evidence, talk about the burden and how you've either met that burden or why the state hasn't proven the burden, right? And we talked about this in opening, why you win, why they lose, right? And make your conclusion. When you do, when you start your closing arguments, make sure that you are persuasive, right? Prepare your closings. Don't wing this stuff. It doesn't matter how many trials I've done at this point after 18 years, I always write my stuff out. And then I ended up rewriting it until I can narrow it down to only a few bullet points, because by that time I should know what my case is and what it is I need to focus on. Use the jury instructions, 3.9, weighing the evidence is really good. Use your time wisely, especially if you're the defense, right? You get the middle part of the sandwich, but you get that amount of time and that's it. You don't get another shot to come back, whereas the state, we get to kind of talk about our case, listen to what you're talking about, and then we get another bite at the apple. If you're the defense, make sure you rebut all the ways that the state has proven their case. If I'm on a trial, I may be using something that I used from Voir Dire to get my point across. Maybe I didn't talk about it in opening, or maybe I just hinted on it, but I may use that to say, hey, remember when we talked about X, Y, and Z? And I will use that from Voir Dire to make my point. Presumption of innocence. A lot of times, many prosecutors will usually say something to the effect of, the presumption of innocence no longer exists. I've heard like when the defense likes to say they are cloaked in the presumption of innocence. The state will say something to the effect of, we have removed the cloak. You can, see, the defendant in his guilt. And then there's a good case from the Florida Supreme Court in 2010 called Desur, 55 Southern 3rd 478, and it where the court said, and when we started this trial, he had a presumption of innocence, and he only enjoyed that presumption at the start of the trial. Once the first witness was called, once the evidence began to be presented, the state chipped away at that cloak. That shield he can no longer hide behind, and as he sits here now, he no longer enjoys that presumption because we have proven our case. And the court basically found that that was a proper argument to be made. What are some things not to do during closing arguments? Obviously, don't attack or disparage opposing counsel. Don't yell conclusions at the jury. I know we like to joke that these are, 6 or 12 people who couldn't get out of jury duty, but they do have intelligence. You don't need to just yell at them. You do need to convince them. Explain to them how all those puzzle pieces that you have are fitting together, or how you have deconstructed the state's case. Again, don't read no bullet points. Don't make baseless arguments, and really, don't burden shift if you're the state. Both sides should be aware of golden rule violations. As the prosecutors, we shouldn't be arguing about sending messages to the community. That is improper. But at the same time, it's also improper for the defense to seek sympathy from the juror for their client, for their defendant, for the defendant. Excuse me. All right, real quick, last things on sentencing. Okay, I provided you guys a chart. It is a chart that we've had. This has been in play in Broward County for years. And as somebody recently talked about, one of the previous speakers, the real issue comes in when you start to see those second within 5s or those third within 10s, because those are the ones that carry with it the mandatory minimum jail time that the court has to have. You'll also see there, this is a very good cheat sheet for anybody who wants it. And if you want a better copy, feel free to reach out to me. I will gladly give you a copy. I've got no problems with both sides having this. But also notice, right, that third DUI, especially if it's within 5 years, within 10 years, that could also be filed as a felony. And, the third DUI can be filed as a felony, not within 10 years. If the state can properly charge it as a felony if they have the requisite priors. And both of those priors have to be, the defendant has to be represented, and they have to be able to get those certified copies of convictions. And they have to be, like I said, represented, or at least waive the representation on the record. But that's it. That's all I have. If you're still with us, I apologize for going over 15 minutes, but there was just a lot for the prosecutor to cover on state and defense issues. If anybody is still with us and has any questions, I'll be glad to answer them. If not, thank you guys for joining us. Thank you for Rossen Law Firm for having me here. I'll ask him for a little bit more time next time, but that's it, and appreciate your time. Thank you.